Hi students, I am Professor Kshitij Bansal. I teach law at Jindal Global Law School. I am going to brief you in this program on the rights of sexual minorities, regional human rights framework. What is there for you to learn from this briefing? You all would be introduced to the 4 regional systems for protection of human rights. You would be introduced to the way in which these 4 regional systems specifically protect the rights of sexual minorities. The issue of sexual minorities is not something which has been borne out in the recent years, but has been a topic of ridiculement amongst various groups for centuries. But over the past few years, there have been various measures put forward by governments of different countries to recognize them and recognize their place in society. Cultures, practices, customs, they all play a vital role on how human rights were formulated. For this very reason, a regional system can efficiently monitor the implementation of human rights more efficiently. This module analyzes various initiatives at these regional systems for sexual minorities in specific, various initiatives under the international level to protect the rights of sexual minorities has also influenced the regional human rights law. And as a result, they have also taken various measures for ensuring and protecting the rights of sexual minorities. Currently, there are 4 major regional systems for human rights protection: European Union, Organization of American States, African Union, and the Arab League. Among these systems, except the Arab League, the rights of sexual minorities are received more well in the recent decades. The importance of these regional human rights systems lie in the fact that they can strengthen the protection and enjoyment of human rights by taking into account their regional considerations, such as shared regional customs, values, culture, and practices. Moreover, it is considered that the regional systems can monitor the implementation of human rights provisions more effectively than an international body. It is informative to analyze various initiatives at these regional systems for specifically sexual minorities. European Union. Amongst the different regional organizations, the European Union has a rich history of protecting the rights of sexual minorities. Within EU, the European Court of Human Rights has dealt with the issue of sexual orientation since the early 1980s by applying the European Convention on Human Rights and fundamental freedoms on the basis of violations of the right to privacy. The development of protection of rights of sexual minorities in EU is mainly based on various judicial interpretations. In Dudgeon versus the United Kingdom, the European Court held the criminalization of homosexual conduct in Northern Ireland violated Mr. Dudgeon's right to privacy under Article 8 of the European Convention on Human Rights. This ruling was followed in cases like Norris versus Republic of Ireland and Modinos versus Cyprus. Further, in Lustig-Preen versus United Kingdom, the European Court ruled that the Ministry of Defence's ban on homosexuals from the military was discriminatory and offended the European Convention on Human Rights. In Salgueiro da Silva Mota versus Portugal, a father had been deprived of the custody of his children during divorce proceedings because of his sexual orientation. It was held that such an action is violative of his right to equality. In Alexeyev versus Russia, the court found that a ban on a gay pride parade, because the parade could provoke violent reaction, violated the right to non-discrimination. The court found that such a ban is incompatible with the fundamental values of the European Convention if the exercise of convention rights by a minority group were made conditional on it being accepted by the majority. EU has also adopted various instruments for the protection of sexual minorities. As early in 1981, the Council of Europe has adopted a specific recommendation for the protection of rights of sexual minorities. The recommendation highlights that all individuals, male or female, having attained the legal age of consent provided by the law of the country they've lived in, and who are capable of valid personal consent should enjoy the right to sexual self-determination. It recommends that Committee of Ministers to urge those member states where homosexual acts between consenting adults are liable to criminal prosecution to abolish those laws and practices, urge member states to apply the same minimum age of consent for homosexual and heterosexual acts, call on the governments of the member states to order destruction of existing special records on homosexuals and to abolish the practice of keeping records on homosexuals by police or any other authority, to assure equality of treatment, no more, no less, for homosexuals with regard to employment, pay and job security, particularly in public sector, to ask for the cessation of all compulsory medical action or research designed to alter the sexual orientation of adults, to ensure that custody, visiting rights and accommodation of children by their parents should not be restricted on the sole grounds of homosexual tendencies of one of them, to ask prison and other public authorities to be vigilant against the risk of rape, violence and sexual offences in prisons. It is to be noted that these recommendations are non-binding and only provide guidance. The Treaty of Amsterdam 1999 under Article 13 confers the European Parliament the power to combat discrimination against sexual orientation. It is the first international treaty to explicitly mention and protect sexual orientation. On the basis of this authority in 2000, the European Council adopted a binding general framework directive on equal treatment in employment, prohibiting direct and indirect discrimination on the grounds of religion or belief, age, disability, or sexual orientation. Article 1 of the directive explains its proposal in the following words. The purpose of this directive is to lay down a general framework for combating discrimination on the grounds of religion or belief, disability, age, or sexual orientation as regards employment and occupation, with the view to putting into effect the member states the principle of equal treatment. Further, the EU Charter of Fundamental Rights 2000 expressly includes sexual minorities under the Charter and guarantees various rights. Article 21, Clause 2 of the Charter states that any discrimination based on any ground such as sex, race, color, ethnic or social origin, genetic features, language, religion or belief, political or any other opinion, membership of a national minority, property, birth, disability, age or sexual orientation shall be prohibited. The Council of Europe has also established the Sexual Orientation and Gender Identity Unit within the Council of Europe, which is responsible for working with relevant stakeholders on the issues of sexual orientation and gender identity issues. Moreover, the Commissioner for Human Rights published an issue paper, Human Rights and Gender Identity, in the year 2009. In March 2010, the Council of Europe adopted recommendation numbered CM-REC 2010 on measures to combat discrimination on grounds of sexual orientation or gender identity, emphasizing the need for universality of human rights and the importance of non-discrimination. The recommendation called upon member states to take positive steps to protect the rights of the LGBTI community. The Council of Europe also published a 2011 report, Discrimination on Grounds of Sexual Orientation or Gender Identity in Europe, which addresses homophobia, transphobia, and discrimination within 47 member states of the Council of Europe and makes recommendations for their prevention. Let us now talk about the Inter-American system. In Inter-American regional system, the human rights bodies responsible for protecting and enforcing the human rights are Organization of American States, they are International Inter-American Commission on Human Rights, and the Inter-American Court of Human Rights. Both these adjudicatory bodies have taken various steps to protect the rights of sexual minorities within American region. the case of Marta Alvarez versus Colombia was the first case concerning a sexual orientation heard by the Inter-American Commission on Human Rights. Marta Alvarez stated that she was denied conjugal visits from her same-sex partner, while heterosexual couples within the same prison were granted this right. The Commission decided that the case was admissible, meaning it gave an unpublished report of its findings and recommendations to the state, giving the state time to comply with. If the state fails to comply, the Commission can submit the case to the Inter-American Court of Human Rights for a binding decision. In 2011, considering the serious discriminatory practices and other violence against sexual minorities, and for developing an adequate framework for protecting the rights of sexual minorities, the Inter-American Commission on Human Rights, IACHR, created a unit on rights of lesbian, gay, bisexual, trans and intersex persons. The main focus of this unit was preparing thematic regional or country reports on the situation of LGBTI persons in the Americas, developing standards on the interpretation of the Inter-American human rights instruments with respect to sexual orientation, gender identity, gender expression, and body diversity through the individual petition and case system, providing technical advice and input to states and political bodies of the Organization of American States, and monitoring the human rights situation of LGBTI persons and promoting the visibility of violations against their human rights. In order to provide a more focused attention to work of Commission on the Promotion and Protection of Human Rights of LGBTI persons in the Americas, the IACHR decided to create a rapporteurship on the rights of lesbian, gay, bisexual, trans and intersex persons in November 2013. This rapporteurship will continue with the works of IACHR unit on those same topics. Between June 2008 and June 2014, the General Assembly of the Organization of American States approved 7 resolutions concerning human rights, sexual orientation, and gender identity. These resolutions acknowledge and condemn discrimination and acts of violence against members of LGBTI community and call upon states, the IACHR, and other bodies to take appropriate measures to address the problem. For example, in its 2009 resolution, the OAS has resolved to condemn acts of violence and related human rights violations committed against individuals because of their sexual orientation and gender identity, and to urge states to ensure that acts of violence and human rights violations committed against individuals because of their sexual orientation and gender identity are investigated and that their perpetrators are brought to justice. In its 2012 resolution, Organization of American States very clearly addressed the issue of rights of sexual minorities. It also resolved to condemn discrimination against persons by reason of their sexual orientation and gender identity, and to urge the states within the parameters of the legal institutions of their domestic systems to eliminate, where they exist, barriers faced by lesbians, gays, and bisexual, transsexual, and intersex persons in accessing the political participation and other areas of public life, as well as to avoid interferences with their private life. It further stated that OAS will encourage member states to consider, within the parameters of the legal institutions of their domestic system, adoption of public policies against discrimination by reason of sexual orientation and gender identity. The resolution again expressed its disapproval against the acts of violence and human rights violations committed against persons by reason of their sexual orientation and gender identity, and to urge states to strengthen their national institutions with a view to preventing and investigating these acts, violations, and ensuring due judicial protection for victims on an equal footing, and that the perpetrators are brought to justice. It further recommended to the member states to ensure adequate protection for human rights defenders who work on the issue of acts of violence, discrimination, human rights violations committed against individuals on the basis of their sexual orientation and gender identity. Thus, by the adoption of this resolution, the Organization of American States has broadened its approach towards the protection of rights of sexual minorities. In 2013, the Organization of American States adopted a binding instrument, that is the Inter-American Convention Against All Forms of Discrimination and Intolerance, which specifically protects the rights of sexual minorities. In Article 2, it states that every human being is equal under the law and has a right to equal protection against any form of discrimination and intolerance in any sphere of life, public or private. Further, in Article 3, it states that every human being has the right to equal recognition, enjoyment, exercise and protection at both individual and collective levels of all human rights and fundamental freedoms enshrined in their domestic law and in the international instruments applicable to the states parties to this agreement. For the purpose of this convention, it defines discrimination as any distinction, exclusion, restriction or preference in any area of public or private life, the purpose or effect of which is to nullify or curtail the equal recognition, enjoyment or exercise of one or more human rights and fundamental freedoms enshrined in the international instruments applicable to state parties. Such discrimination may be based on nationality, age, sex, sexual orientation, gender, identity and expression, language, religion, cultural identity, political opinions or opinions of any kind, social origin, socio-economic status, education level, migrant, refugee, repatriate, stateless or internally displaced stateless, disability, genetic trait, mental or physical health condition, including infectious, contagious condition and debilitating psychological condition or any other condition. Thus, it can be seen that in the inter-American regional system, the rights of sexual minorities are protected to a very great extent. Let us now talk about the African Union human rights system. In African Union, the bodies which are responsible for the protection and promotion of human rights are the Organization of African Unity and the African Commission on Human and People's Rights. The major human rights instrument in this regional framework is the African Charter on Human and People's Rights, 1981. This is a binding human rights instrument, has been unanimously ratified by all African Union member states. The Charter affirms in broad terms the equality of all people before law and the right to freedom from discrimination. Article 2 of the Charter states that every individual shall be entitled to the enjoyment of rights and freedoms recognized and guaranteed in the present Charter without distinction of any kind, such as race, ethnic group, color, sex, language, religion, political or any other opinion, national and social origin, fortune, birth, or any other status. Article 3 guarantees that every individual shall be equal before law and that every individual shall be entitled to equal protection of law. Though right to non-discrimination and equality is recognized to everyone by the Charter, the treaty does not contain any direct provision for the protection of the rights of sexual minorities. It is to be noted, although, that the African Charter grants rights to everyone without distinction under a state party's jurisdiction. The formulation that every individual is entitled to the rights in the Charter is repeated in around 12 articles. Further, in Article 2, the right of every human being to respect for life is reiterated. Article 8 provides that the freedom of conscience of no one may be restricted. Article 13 provides for the rights of every citizen. It can be argued that the terms everyone, every human being, and no one include sexual minorities also. Further, the rights under the Charter are guaranteed to every individual without any distinction of any kind, such as race, ethnic group, color, sex, language, religion, political or any other opinion, national or social origin, fortune, birth, or any status. It can be argued that the word other status includes sexual orientation also. This is because the same word in ICESCR has been interpreted by the Commission on ESCR in its general comment to include sexual orientation as well. Further, it can be argued that the word sex used in Article 2 includes sexual orientation. This is because the word sex in ICCPR has been interpreted by the Human Rights Committee as including sexual orientation. The reason for citing the interpretations given to these terms by the UN bodies and the claim for assigning the same interpretation to these words in the African Charter is because of Article 60 of the African Charter. The Article 60 states, the African Commission should draw inspiration from international law on human and people's rights, particularly from the provisions of various African instruments on human and people's rights, the Charter of the United Nations, the Charter of the Organization of African Unity, Universal Declaration of Human Rights, other instruments adopted by the United Nations and by African countries in the field of human and people's rights, as well as from the provisions of various instruments adopted within the specialized agencies of the United Nations, of which the parties to the present Charter are members. Thus, while interpreting the provisions of African Charter, the African Commission are expected to incorporate developments in international human rights law. Therefore, the interpretations given to the words other status and sex by UN bodies should be considered by the African Commission while interpreting African Charter provisions. It can be seen hence that sexual minorities, although not explicitly, but are entitled to claim protection under the African Charter. The view has also been recognized by the African Commission in its decisions. For the first time, the African Commission discussed the issue of protection of sexual minorities in the case of William Courson versus Zimbabwe. In this case, the complainant challenged the criminalization of sexual conduct between men in Zimbabwe and the utterances of senior political figures condemning the practice. However, the Commission did not make a finding because complainant withdrew the case. The Commission got another opportunity to discuss the issue of rights of sexual minorities in the case of Zimbabwean Human Rights NGO Forum versus Zimbabwe. The Commission stated that non-discrimination under Article 2 of the Charter aims to ensure equality of treatment for individuals irrespective of a number of grounds, including sexual orientation. Recently, the African Commission on Human and People's Rights adopted a resolution on protection against violence and other human rights violations against persons on the basis of their real or imputed sexual orientation or gender identity. This resolution condemns the increasing incidence of violence and other human rights violations, including murder, rape, assault, arbitrary imprisonment, and other forms of persecution of persons on the basis of their imputed or real sexual orientation or gender identity. It also condemns the situation of systematic attacks by state and non-state actors against persons on the basis of their imputed or real sexual orientation or gender identity. Further, it strongly urges states to end all acts of violence and abuse, whether committed by state or non-actors, including by enacting and effectively applying appropriate laws prohibiting and punishing all forms of violence and persecution, including those targeting persons on the basis of their imputed or real sexual orientation or gender identities, ensuring proper investigation and diligent prosecution of perpetrators, and establishing judicial procedures responsive to the needs of victims. Thus, it can be seen that various initiatives have taken place in the African region, also to protect the rights of sexual minorities. It is now logical and helpful to conclude that this module provided us with a holistic understanding of how the different regional systems protect rights of sexual minorities through various initiatives. Further, it shows how various treaties, commissions, and other instruments play a vital role in shaping up the human rights jurisprudence on the rights of sexual minorities. There have been various initiatives internationally to protect the rights of sexual minorities, these initiatives in effect have also affected the regional human rights laws. Currently, there are 4 regional systems for the protection of human rights. We've discussed 3 out of them, the European, Inter-American and the African. We have not discussed the Arabian region, the Arab League and its regulations, for the reason that it does not give due attention and importance to the issue of human rights. We are not even required to mention whether Arab League gives any importance to the issue of sexual minorities. It does not. I hope this was interesting. I hope this has introduced you to the controversy in the discussion around the rights of sexual minorities, which, by the way, is contemporarily very relevant in India in the wake of still having homosexual acts as a criminal offense in our Indian Penal Code. The matter is sub judice in the Supreme Court. I hope the Supreme Court will come out with a progressive decision on this matter. Thank you for listening.